Funding for Austin Business Matters was provided by Division X Incorporated, where e-commerce meets e-marketing. Today's episode is Intellectual Property for Startups and Small Businesses with Andrew Eisenberg, hosted by Dr. Atola Etemadi. Welcome to Austin Business Matters, the show to help you succeed in your business. I'm your host, Atola Etemadi, and today I have the pleasure of having the company of Andrew Eisenberg from Lee & Hayes. Please, could you tell us a little bit about yourself, Andy?
Yeah, sure. I'm actually a partner with Lee & Hayes. I'm a patent attorney, and I've been an inventor on several inventions. I named inventor on several patents, and I worked at a startup company for several years, and then now I'm in-house, and I'm glad to be here.
Welcome to the show, Andy. Could you tell me, in a nutshell, what is a patent?
So, I mean, there's a couple of things. In the most basic, it's something that's inventive, it's new. Some of the requirements are it has to be useful and it has to be non-obvious. So it needs to be something that you've come up with and something that's never been done before. It's kind of the basic. And it has to be useful, so it's not creative like a copyright or something like that. It's not a book. It's an invention.
Can anything be patented, or are there certain areas in which patents are more applicable than others?
Yeah, so most everything can be patented. It's really broken down into about three areas. There's the mechanical engineering, there's the chemical and life sciences, and then there's electrical engineering and computer science and coding. Those are kind of the three areas. There's a couple of exceptions. It can't be for illegal purposes, which means you can't make some kind of weapon that's going to kill someone and only be used to sell on the black market. You can't do something that's found in nature, so you can't discover something. You can invent a process of isolating a chemical or something like that, but you can't find something in nature and then go ahead and patent it. You can develop plants, you can develop DNA, you can do all kinds of stuff like that, but those are kind of the two exceptions.
Right. So when you say DNA, is that restricted to non-human DNA or all DNA?
No, it's all DNA, but you have to do something to it. So it has to be like a man-made something. It can't be. You can't go and patent a human being. You can't patent a cow. You have to come up with something different. So it's mostly useful for like your genetically engineered plants.
Okay, so genetically engineered sheep that we heard about a while back.
Yeah, that he wasn't patented, but they could have been. I mean, at the time it was kind of up in the air. It's moved towards, yes, that is something patentable, and the pharmaceuticals use it a lot, and they spend a lot of money on it. So it is something that needs to be protected so they can get a return on their investment, and it has a lot of benefits to just the citizens of the United States, in that they get drugs that they wouldn't otherwise be developed.
Now, I mean, one of the questions I get asked quite often is things like food and recipes in general. Is that something that can be patented or copyrighted?
Yeah, so it's not really like your recipe can't be patented, and the real reason isn't it can't be patented, but that you can only patent a certain thing. So you could change. I mean, you add some salt to something, then it's no longer falling under your patent. So it's almost impossible to do so. It's a good thing to fit into trade secrets, so you keep it a secret. If you've got some signature look to your food, like you have a special cupcake or you have a special design you put on all your food, that can be trademarked. So that can provide some protection that's not typically what people think about, but it's not just it's not just straight up with a patent. It wouldn't do you much good.
Right, so if I have some sort of secret sauce or something, it's better kept a trade secret.
You better keep it a secret, and even though people can kind of figure out what's in there, but keeping your particulars a secret is the best way to go there.
Another thing that I get asked quite often is about provisional patents, and there's a lot of information on the web, but because there's a lot of information, it's really difficult to extract the So I mean, in the most basic, a provisional patent is a placeholder. It gives you 1 year to file your utility or non-provisional application. They never publish, so they really can't be used against you. But I don't particularly like them. There's some very specific situations you can use them, but what I find is most people, they're trying to do them because they're less expensive. They're trying to save money. They don't really engage an attorney. They go and try and do it themselves. And what happens is something gets left out. And then it turns out 3 years down the road, when you're in prosecution with the United States Patent and Trademark Office,
arguing about what you actually invented. A lot of times what you invented was not significantly described in enough detail, and you can lose your patent. And they really set up a lot of traps for people. So unless you've got something where you're trying to figure out that, hey, I have a new chemical, I have a new drug that's going to treat this particular disease, I'm ready to do the testing, I'm not sure it's actually going to work or not, so maybe you file your provisional, and then if it doesn't work, you start over again with a new drug, and it doesn't cost you a lot of money, but at the same time, you already knew what you had, that kind of thing.
I mean, one of the reasons that most people tell me they want a provisional patent is because they want to go out and raise funding, or they want to get a team together.
Yeah, so it can be useful for that. I mean, the fees are pretty similar for a small entity, so you're starting up a business. The government fees for filing a regular application and a provisional are pretty similar. The attorney fees, they can vary a lot depending on how you work it out with the attorney. They'll tend to try to save you some money because they're supposed to be less expensive. But I find that you typically are pretty close to what it would cost for a full application. And in almost always case, it's better to do it. If you do have some investors lined up, so you're ready to go, in the next 6 months, or you're already engaged with an investor and you just need to get something on file with them to say, hey, I have a patent, to check their box, or you can do it within 1 year, you're going to have the money to move forward, or even 9 months because you still have to have time to prepare the new application, then it can be a useful tool.
Well, one of the things that happens is if you want to convince somebody else to join your team before you even see an investor, they really want you to have convinced at least one other person.
Yes.
And, it's difficult, to get people to sign NDAs. So provisional patent is usually...
Yeah, it can be good to showing someone, hey, you actually have an idea. I mean, if you're trying to bring on employees, a lot of times you can bring them. The employees often will sign NDAs. What I find is investors won't. And the reason they don't want to do that is they don't want to invest in a company that's similar to what you proposed, and then for you to come back and sue them under the NDA saying, hey, you took my idea, when they didn't even remember your idea. They see so many of them. So a lot of them just out of practice won't. Some of them will. If they will, that's a much better route to go than I think filing your provisional before you're ready. But if you're trying to show people that you've got something, you can put it down. You just have to be aware that you have 1 year to file your application, and you have to plan for that. So if you're just trying to defer costs, I don't think it's a good idea. But if there's some other reason, like, hey, I got this guy and I want to talk to him about being my partner, that's a good reason.
Right. One of the other things that I get asked, there's no such entrepreneur who just comes up with one idea. Usually they have like 10 or 15 ideas. Yeah. And of course, doing 10 or 15 separate patents to start off with is going to be usually outside their means. Can they put them all under one?
So they can. This is the kind of stuff that I actually really enjoy doing with working with a startup company. Hey, we've got an idea. We actually have a lot of ideas. Here's what they are. What should we be doing? This is what our budget is. How do we best protect this? And should we spend a little bit more? Should we spend a little bit less? Can we defer costs out? So you can put it all into one application. You can get one really large application. You just got to make sure when you're writing it, you're planning on splitting it back up. So the best thing to do is always to file separate applications for each thing. That allows you to license them independently. So if one idea is great for, I don't know, use on the water, and another one's great for use on the land, you could license them separately to two different companies. If you start with one patent, we have to file what's called a terminal disclaimer, and that ends up saying, hey, these two patents are related. We will license them together for the rest of the life. The other thing is you get your time based on each of the separate applications. If you file them as, say, you had 15 ideas, filed 15 different applications, each one's going to have its own clock for when it expires. If you file one and it takes you 3 to 5 years to get your first application, then you file a second one, all of the subsequent 1, 2, 3, 4, 5 are going to be based off of the time limit on the first one. So for the second and third, it's not so bad. If you file all 15 at the time, say 3 years down the road, that's not so bad. But if you file them serially, you might end up with some patents that only get 3 months. They might get a year. And then it's a question of how valuable is it. But it is. The other thing is what I find a lot of people don't understand, that if you have one application, it's pretty easy for a large corporation to defend against it. If you've got 15, it's really difficult and becomes really expensive. And now maybe they're willing to come to the table. So you can by breaking it up you create more leverage for yourself. So there is some downfalls to just filing one.
I mean, usually it's a matter of just simply not having the funds to do like 20 patents. But I get your point. It's if you can stretch it to 5, it's better than 1.
Yeah, like so 1 is good. 3 is better. Portfolios are already 5 is really good. 10. Once you get to 10, I tell people, all right, now we really need to start paring it back. We're going to be wasting money. Let's pick the good ones. I had one client who came in and we did 40 provisionals. We ended up with 20 patents because it was just going to be unbelievably expensive to prosecute 40 applications.
Yeah, I mean, most entrepreneurs are, trying to do things on a shoestring budget to start off with. So, but as I said, they're prolific, so they would want to get as much done.
So it's really all about the planning up front and sitting down with an attorney and saying, hey, I have all these ideas, and tying it back to when in my business plan am I going to have the money to do this? When do I think that's going to be? And then give yourself some room and make sure you don't miss anything, but just to lay out a strategy going forward. That's really the best thing you can do.
Now, the purpose of a patent, is it to show that you can actually create something, or is it to stop somebody else from?
Yeah, so it's really so if you get a patent, that doesn't mean you can do it. It means no one else but you could do it. So the typical example is I have a patent for a 3-legged stool. You invent a patent for a 4-legged chair. Well, you can't build your chair because it has 3 legs. So I can stop you from building any type of sitting device that has 3 legs because that's what my patent says. But I can't go ahead and build a chair with 4 legs. I could build my stool with 3 legs, but you own the patent for the 4-legged chair. I can't do that. Only together could we go ahead and by cross-licensing move forward. So it's really to prevent someone else from using your idea, not necessarily, it's not like a hey, you're going to be clear and no one's ever going to come after you for your invention.
I mean, do you actually have to prove that thing is actually doable, that you can actually achieve the end result?
So it needs to be, the idea is that someone skilled in the art, so if you're doing a software patent, someone who has a degree in software could actually take what's written in the patent and kind of build what you described. It doesn't have to be in sufficient detail that someone can just go take it and stick it in a computer. The code doesn't even make it into the application. So you have to, and the patent office will take it on your face value that you're submitting the patent that you can do it. So you don't need to build a prototype. A lot of people think you actually have to build it. At one point you did have to send in a prototype, and then they had too many of them. They were storing them all in the patent office, and some of them are huge machines, so they just said for ease of practicality, we're going to take your word that you can do it. But the idea is that someone who reading the application, who's skilled in the art, would be able to eventually, given enough time, do what you said you did.
And for example, like chemicals, are they something that are easily patentable, or is it the process of creating a chemical?
So it's both. I mean, when the pharmaceutical companies, they start going, and they typically, I mean, when I say you should have a lot of patents, that's more along mechanical computer science. They end up with 1 or 2 patents, and normally the one's for the actual chemical itself, and maybe all of the variants that they can think of at the time of filing. And then the second one is about their process for making it, their process for isolating it, and how they can go about and achieve that. And oftentimes that's the more valuable patent, because the chemical is often very difficult to prove that you invented a chemical and that it didn't exist. The drugs, when they're so complex, if you come out with an antibiotic, they're going to let you have a patent on it. But if it's just some simple, I mean, you've got some calcium and carbon and you put it together, it becomes difficult. But the process can be much, much easier with a patent.
One of the misconceptions, or maybe it is a misconception, I don't know, is that software can't be patented. Is that true, or is there a way you can patent it?
Software can be patented. It's been a misconception for a long time. A lot of people believe that you shouldn't patent software. My opinion is that it doesn't really fit in copyright. You're putting time and money and effort into it. You do something inventive. 2 people can write code to do the same, the same process. They get the same end result, and it wouldn't be a copy. So copyright doesn't really apply. So you can do that with your code, but it only helps if someone actually stole your code. On the other hand, the patent is, I can patent the process of a computer receiving data, processing the data, processing step number 2, 3, 4, 5, 6, 7, applying algorithms, and then transforming the data into something new that you can present to the user. That's patentable. Today, a lot of the issues there was a case called Alice, and it basically came out and said, if it has to be tied to improving a machine. So it doesn't mean that you can't patent software, but that a lot of things that you have to have some improvement.
For example, the famous case of the Amazon one-click purchase.
So, yeah, that's one of the big ones. What they basically have been saying is that, hey, instead of processing data associated with 2 clicks, we removed 1 click, and now we're processing data of 1 click. So we're improving the entire server exchange system by reducing the amount of data that has to go back and forth. It improves speeds, and it makes things easier. So that's how they frame that. Does that make sense?
That does make sense. I mean, but it's a very gray area because just saving a few seconds of time is not necessarily but adding a lot to the equation there. So
yeah, I mean, you look at the mobile devices. I mean, the companies are fighting over millimeters of space. So if they can reduce something by 1/10 of a millimeter, I mean, that's worth a patent to them because they can say, hey, they've got the thinnest device, and people will actually go and buy it. So there is something to say that, hey, people are really buying things because of these improvements. So how small is not so much what matters. What matters more is, was it obvious to do that? So would somebody have done that at the same time that you were doing it? If someone just looked at the problem, would they come to the exact same conclusion that you came to without really any effort? And that's the question that the patent attorneys and the examiners at the patent office are trying to solve.
I mean, one of the questions I get asked quite often is, okay, I submitted my provisional patent. It's coming up to near the end of it. What do I do?
So, well, you started your time. You got your year. You really need to convert it to a non-provisional application, which means a full application, 20, 50, 100 pages. But that's really, if you haven't already, that's time to get in touch with a patent attorney and to see what the next step is. If you haven't publicly disclosed it, almost always I find that clients have, then you could let it go and you could start over. You'd lose your filing date, and it's not the best thing in the world, but they don't publish. But your options are either file an application or let it go at that point.
Could you like abandon one patent, provisional patent, say halfway through, and start a new one just to keep it going for years?
You could. So every time you stop, if someone filed a patent in between when you filed your first one and you filed the second one, you would lose that time. So they would get the patent instead of you. But you could do that. I mean, they don't publish, so they're not gonna block the provisional's not gonna block your non-provisional application because it never publishes. But right. You do lose some time, and it's not nearly the most advisable thing in the world to do.
Well, I mean, the reason I ask that is because, things never work out so
That's
straightforward.
True.
So you get to a point where, you're maybe just a few steps away, and then you realize you've only got a few days left on your provisional. Just the way things work. So that's why I was asking that. That's a common. Yeah,
I always tell people, and even though you have a year, plan on 9 months. So if you can get started at 9 months, or if you plan to get started at 9 months, normally you'll get started with enough time to actually finish the application. They take about 4 weeks at a minimum to get ready, and that's if everything goes well. So you really need a month. 2 weeks is doable, but you're really, really pushing it. Anything beyond there, there's probably not an attorney who would pick it up for any reason whatsoever.
One of the problems is that you can't. It's generally difficult to afford just paying for that money, and even if you did, somebody else with billions of dollars can step in and say, find some sort of loophole. So, is there any way for your Joe Public inventor, entrepreneur to protect themselves against that sort of scenario?
Where somebody else is going to just step in and try to patent the same thing or design around your patent?
Or call it something else. A case that comes to mind, and I don't know whether that's true or not, is the Dyson, the sort of tornado.
The vacuum. Yep.
And I think they got around that by saying, it's not a vacuum, it's actually for cleaning the inside of the the device, which is not the same purpose as what.
So the purpose is not really demonstrative. It's are you following the same steps? Are you doing the same thing? Is the device the same? I mean, if someone goes ahead and they claim a vacuum cleaner that improves the suction on a vacuum versus cleaning the inside, and it depends on how it's worded, but to me, you should have been able to word that so that it covered both scenarios.
Is there any way that you can kind of like, because it's not published, is there any way that you could, like, if somebody came along with some other idea, that you could sort of extend your patent to cover that? So
what I always like to do is I like to keep something going at the patent office. So you can get a patent issued, and then you can file what's called a continuation. It's, hey, I'm continuing, I'm going to get another aspect of my invention. As long as you have something that's pending at the patent office, you can continue to file the continuation. If someone comes along and it's close enough and it's covered in your application, but maybe not in the claim, so you describe what's going on, but you have A and B in your application, and you get A in the first one. You could go ahead, and somebody comes out with B. You could go ahead and file a new one and cover B. But it's got to be described in the application. You can't add a completely new. You couldn't come ahead and say, hey, you came out with C. That's different, but I'm going to try to cover it on this patent. But if you actually had the idea and it's described, then you can go after it. So I like to keep something alive. So
can it be something that, you haven't really thought of until somebody else came along with the idea? So, for example, what let's say I do file a patent, and then somebody else comes and files something quite similar, and I'm thinking, I wish I'd thought of that. Could I then incorporate? It's not.
You're going to have to go look at your application and decide if what's describes what they're doing. So if it's really close, you're probably good. If it's not so close, then, I mean, if it's only tangentially related, you might not be able to cover it. What you're going to do is you're going to sit down, you're going to read the patent, and you're going to look at what they've got. And if your patent, you can say, yeah, this sounds the same. I could write a claim, which is the legal aspect of what you get protection for, on what he's writing, what his application says, then you could do that, yes.
Right, okay. And is there, for your average entrepreneur, what's the best way of going about it? Is it to hold on to the thing? Let's say you've got the funds to file a provisional patent. The problem is somebody else could come at any second and file that same idea.
Well, once you have your patent filed, you get priority to anyone who comes later, whether it's a provisional or a non-provisional. If you've got it filed, you get the priority. We're in the first to file, and so whoever files their application first gets to own it in the end. So what would happen is if you filed your provisional, they went and filed a utility, you file your utility, they're both going to publish at some point, and then the examiner's going to find your application and say, hey, you don't get yours. He filed his 2 years before you, or 16 months before you, so he wouldn't get a patent and you would.
So when it comes to patent searches, though, you can't find these...
So the provisionals only publish if you convert them into non-provisionals. So if that happens, you didn't make a public disclosure. If you really want to stop someone from patenting your idea, you can go and publish a white paper. That means you're going to destroy your rights to the patent because it's now in the public domain. The reason you get a patent is because the government says, hey, if you disclose this to the public, we'll give you the rights for 20 years. You just donated it to the public, so now the government's there's nothing to exchange with the government. So once it's published, nobody can get the patent on it at a later date.
The law was recently changed about this whole America Invents Act and so on. And what's the thing that you've come across as the most common problem, common issue people face?
Well, so the real big difference between what we had before, which was first to invent, so that's how America had done it forever. It's, if you came up with the idea, you would keep these notebooks, and you'd say, hey, I came up with the idea on this date. I worked on it on this date. I worked on it on this date. If you couldn't afford a patent, and say 2 years down the road, you file your patent, and somebody in those 2 years came up with the same idea, but you came up with it, say, 1 year after you did, then they filed their patent. You would have been able to keep the patent because you invented it before them. Now we have what's called first to file. So because you waited 2 years and he came up with it 1 year after you and then filed immediately, he would get the patent and not you. So it's still good practice to keep your notebooks and to keep things up to date, but the big change is there's actually some you do need to file as quickly as possible, versus before, as long as you kept good notes and you continued to work on it, you would win the patent versus somebody else who came up with the same idea at a later time.
Okay, and I mean, is this the same all over the world? Or
yeah, so that's what the big change was, to bring the U.S. law in line with the rest of the world. That was the reason that the government gave us for changing it. We were really the only country that was doing it this way, and it's just a difference in how patent law developed in different countries.
Do you happen to know who's the country with the biggest, the most number of patents?
Oh, that's the United States. Yeah, right. By a long shot.
So that's sort of strange then. I've heard a little bit about patent trolls. I don't exactly know what they are.
So we call them NPEs, non-practicing entities, and I kind of see a difference between non-practicing entities and what people refer to as patent trolls. Non-practicing entities, I think, covers anyone who doesn't have they're not selling a product and they own patents. So that could be, hey, you did your startup failed, but now I've got 20 or 30 patents, and somebody copies your idea and then you go after them. That to me is a non-practicing enemy. You spent the money, you developed a product, you just didn't make it. On the other hand, we have people who all they do is they buy patents from other people and then they go and enforce them. That I still see as a legitimate use, because they're buying a property and they're going after someone who actually infringes their product. Then what I like to call troll is these people who they buy 200 patents and they're in general areas and they don't really care if you infringe or not. They sue you and say, hey, I want a small amount of money, maybe 1/10 of what it would take to litigate it, or to get to a point of summary judgment, and say, why don't you pay me this small amount of money? It's going to cost you more money to even hire an attorney to defend these, and then they go away. They're really just using the system to get money from a lot of people, and that's what I see as the real problem. And it's tied to the cost of litigation, the cost of obtaining a patent, the cost of defending it. But I don't think that all of these non-practicing entities fall into it, because if you really do, you put millions of dollars into a company and it fails, you came up with the ideas. If someone then goes, oh, he failed, I can see what he's doing, and copies it, or does the same thing, you should have a right to get some money from that. It was still your idea, and you went through the patent process. You paid your government fees to get your patent. You should be able to enforce it.
Is there any protection for your small business who can't afford large sums for fighting things in court? Is there
so there's a couple things you can do. One, you can just ignore it until they actually do file a lawsuit. That works quite often. Another thing that I like to do is I like to prepare some kind of re-examination or review of the patent to kind of challenge the validity of the patent. They might be around the same that the troll is asking you to pay, or it might be less than that. And then what you do is you take 3 or 4 of these and you say, hey, we've prepared these documents. We've already spent all the money. All we have to do is file them with the patent office or with the district court, and we're going to challenge the validity of your patent, or you're going to take it away. And you do it on a Friday, so you give them the weekend to think about it, and then you file it on Monday if they don't. Almost always, the people who are really trolls and they don't feel strongly about their rights to the patents or their rights to you infringing will go, okay, I don't want to risk my patent, because then I've got all these other people who are paying me for it. They're all going to stop the minute that you challenge it, because if my patent gets invalidated, then no one has to pay me for it. So I always try to prepare more than one. 3 is a good number, 5 is a good number, but it kind of says, hey, I'm really going to do business here. You don't want to mess around with me. Go find somebody else.
And is that a small fraction of the cost of what it would normally be?
It would be a small fraction of what it would cost to defend a lawsuit, or even what I find is if these trolls come by and you settle with them, everybody else tends to find out about it, and then you get more people asking and more people asking until you do say, hey, I'm not going to mess around with this, and then they go away. So they don't all go away, but some of them do. And you can take a look at it on a per challenge basis, because some of them are going to be legitimate, but it tends to cur down what everybody gets all upset about in the media.
Well, because on their side, there's no real cost associated with it.
Yeah,
all the cost is on your side defending yourself, correct?
Well, so they kind of change things a little bit. So if they bring a lawsuit and they lose, they have to pay your attorney fees and things like that. So they're trying to make it a little bit more cost effective. but it's all a big question mark of what's going to happen in 10 years, how much money I'm going to have to pay, and you're still going to have to come up with some money now. So they really are using the cost of the procedures to extract a very small amount of money from a lot of people when you compare with what it would cost to defend. And a lot of times the patents should have never been issued in the first place, which is a problem, but and a lot of times you don't infringe. There's not anything anywhere near what you're doing. It's just a lot of stuff about payment processing. So you use some company's payment processing system on your website, and so everybody who uses that system, they're going to come after. And a lot of times there's not even, that system doesn't even infringe. Right. So you got to look at it, but
yeah, because that is really stifling innovation, and small businesses are really worried about that. It's not something that's...
Yeah, people are really worried about it, but then you go and look at it. If you look at countries that didn't really have a strong patent system, there really wasn't this strong startup community. And if you really look into it, if we did something to get rid of it and said, hey, we don't want patents anymore, then what's your protection from the large businesses? And that to me is a bigger problem than a patent troll coming through and asking you for a few $1,000s versus a large company who's going to go, hey, that's a great idea. We're going to build that product, and they're going to do it better than you because they have the resources, and put you out of business. So, I mean, it's kind of a balancing act, but I think a large solution to the problem would be some easy way of throwing out bad patents, or finding this isn't even close. We're not even going to waste any time on this. They've tried to do some things like that, but all of them have turned out to be more expensive than what existed before. So I don't see us really, the government hasn't done a good job of finding solutions. They've put time limits on things like, hey, we're going to turn this in 3 months. And then the patent office goes, okay, well, to turn it in 3 months, I got to charge 8 times what I was charging before. So we can do it in 3 months, but we're going to charge you a lot more money, which doesn't help anyone.
Right. So it's all checks and balances, unfortunately. The other thing I've heard is the famous case of the person who invented the variable speed.
Yeah, the windshield wiper. Yeah,
windshield wiper. Now, I thought that he got like $5 billion, but from what?
So yeah, he got a small amount of money. Yeah, I think that was the jury award, and then I think the judge reduced that down to a reasonable amount. My understanding of it is that actually one of the car manufacturers offered him more money than he ended up getting in the long run, and he had turned it down. And they did is they ended up designing these. Everybody's got in their car the 6 different speeds on a rotator, and his patent was written as if it had to be a continuous speed adjustment. So he ended up losing out on the license that he could have had, and instead they came out with something that works just as well, and they didn't have to pay him any money for. Like I said, he did win the lawsuit, but I think by the time he added in all his court costs and everything, he ended up making less than he would have if he had just accepted the license in the first place.
Is that a calculation that's easy to do?
No, it's really hard, actually. It's, I mean, it depends on where you're at, and typically I find that people value their patents more than they should be. There's ways to do valuations. They can be very expensive depending on how many applications there are to value. But I say if you're going to turn something down, you should at least have a financial person, or there's different groups that can do valuations, and they use special software that's designed for valuing software or valuing patents, and so it can be done, and it's only so accurate at this point. It keeps getting better and better, but you should do it if you're going to turn down a large sum of money beforehand.
Right. Yeah. It's a difficult decision though, because you don't really know whether what they're offering you is a tenth of what it's worth, or if it's
kind of the same decision that I tell people. If you're going to sell your business, would you sell your business for that amount of money? Do you have a business? What are you making any money off of it now? I mean, if you have a business and your patent is defending your business, if someone wants to license it, you might want to just keep it because, hey, you've got a great business going and you don't want to lose that. On the other hand, if you're not making any money off of it, then it might just be a gift. Right.
Yeah. So it boils down to your financial situation.
Yeah.
And that's the worrying thing in a sense, because all of these things boil down to your financial situation rather than how clever or how good was the invention. So if somebody who can't afford to do it comes up with a great invention, they just can't do anything about it. They can't protect themselves. They can't use it.
If you're really in a situation where you have a great invention and it's something that's really good and somebody is infringing it or you want to make a product with it, there's a lot of companies out there, even law firms, who will say, hey, we're going to do all the work and we're going to take 30%. Or people form these corporations and they create funds and they'll raise hundreds of millions of dollars and they'll put them in the fund just for the purposes of going and making money off your patent. So if you have a really good idea, then there is money there, and it's not that hard to find. It's more of if you're starting a business and you've only got a minor difference and there's 10 different ways to do it and yours is maybe a little bit better, then it's harder.
What do you do if your idea has a wider application than, not just in the US, in the sense that, maybe it's targeted at a country where it's extremely hot, for example, like a desert country, just to give you an example. Now, getting a US patent, does that help you any?
So the US patent's only going to help you in the US. If you get something allowed in the US and you filed application overseas, it can be a lot easier to get the overseas applications allowed. There is something called a PCT, Patent Cooperation Treaty application. That gives you about 36 months to pick other countries. It's still not going to give you you still have to file an application in every country. Europe counts all as one. And I find that as long as they speak English, so Australia, Canada, Europe, it's not too expensive. If you start getting into Korea and China and some of these other countries, the translations tend to cost more than even the attorneys do. Just because it's difficult to do, there's few people who can do it, and it needs to really be technically accurate. It's not just translating a sentence. You've got transistors and resistors and stuff that doesn't translate easily. Just the terms don't. So, and it really has to be described correctly. Otherwise, what someone reads in China might not even make any sense, in which case then you're not going to get a patent. So you can go after foreign stuff and you can defer off the cost a little bit, 36 months, but it is expensive.
One of the things that people come to me about is that they might have found somebody in China who can manufacture their product very efficiently and very cheaply, but what they're worried about is that now their intellectual property could just disappear overnight.
Well, as long as you cover yourself in the United States, you're protected here. So China it's getting better. They don't have a lot of protection there, especially if it's a Chinese company versus a U.S. company. It's difficult to do. They are getting a lot better. They're really starting to care about intellectual property. But if someone in China, if you have a patent in the U.S. and someone in China, you tell them exactly how to do it, and you don't have a patent anywhere besides the U.S., they could go and sell it to other people anywhere else besides the U.S., and they're not going to do anything wrong. If you have patents all over the world, then they would be doing something wrong in each country where you have a patent. Another thing, though, is you can get, like, the Border Patrol. So if they ever try to bring this stuff into the United States, they'll seize it, and the government will just take it and put it in a warehouse, and no one will ever see it. So a lot of times what happens is the Chinese company will take it, or some other company will take it, and they won't do anything wrong until they try to bring it into the U.S. where they really want to sell it. And then once they bring it in the U.S., then your patent kicks in.
Okay, then the problem is, it's going to be, if it's expensive to prosecute something in the U.S., it's going to be significantly more expensive to prosecute that in China itself, because that is a huge market in itself.
Yes, so it's more expensive as long as you keep it to it. If you know what countries you want to go to, and you keep it to a handful, it doesn't add that much of expense. It's more. It might be, if you pick 5 countries, it might be 5 times more, but it's not 100 times more. If you just want to go, hey, I want every World Trade Organization country, then you're talking a lot, like 10, 20, 30, 40 times what the U.S. would cost. Most people have an idea of, hey, I want this in Australia, Europe, China, Korea, and Canada and the United States. That's pretty typical, or 4 countries. A lot of even large clients that I work with, they'll do 4 countries, and that's it.
Are there any big countries like India, for example, that it would be difficult to get a patent in, or all the major population centers are pretty much covered.
They're all covered, and they're all pretty much coming together. There's different values at different places. Some countries, they just say, hey, I want a patent, and they go, stamp, you got a patent. And then when you go to enforce it, that's where the costs kick in, because they don't actually decide you actually invented something. They do that when they let that go out in courts and they let you spend the money on it. So there's some countries that are really easy to get a patent in, but then you're going to have a horrible time trying to enforce it. So there's different levels. Most everybody seems to be coming together with kind of where we're at now, which is this first to file, and we're going to do some checks. The Europe actually does a really good job. They do their own checks, while as other countries will just look at what happened in the U.S. and say, okay, the U.S. gave you a patent, we think you should get a patent. Or they'll even wait. They'll say, hey, we're going to wait to see what happens in the U.S. before we tell you anything.
When you visit the patent office and you do a search, it does bring up patents that are like 50 years old.
Yep.
Are they still relevant?
So they're no longer enforceable against you. So somebody can't take a patent that's expired and use it to stop you from building something. At the same time, it does affect whether you should get a patent or not. So if you decide, hey, this 50-year-old technology, and you make an improvement on it, or you do some other way, that 50-year-old technology is prior art. It's been done before. If somebody's done it before, then you shouldn't get a patent on it.
Right. Yeah. I mean, that's a very difficult situation for an inventor and entrepreneur who's not a lawyer to try and figure out what is prior art in their case. Although it sounds pretty straightforward in most cases, sometimes it's very, very subtle.
Yeah, it can be very difficult. And the honest question is, the U.S. Patent Office has one of the best search engines in the world, and they have access to more documents than you're going to have access to. So there's a really good chance that they're going to find something that you're not able to find. And so it's really, you do your best searching. If you find it in a few minutes, that's probably a bad sign. If you search for a couple hours and you don't find anything, then you're probably in a pretty good place where you'll get something. You might not get exactly what you thought you were going to get, but you're going to get something. You're not going to have wasted your money. That's kind of you can also hire search firms that do a really good job. They charge you, and that's all they do is they go and find stuff. So that's one way to go. I typically don't recommend people do that, because if you can't find it in a couple of hours, the stuff that you're going to get from a search firm is probably going to be similar to what you're finding, and it may be a little bit better, but probably not worth the expense.
Now, if something is patented, let's say in China, but not in the United States, does that count as prior art?
It also counts as prior art. So that just has to be done before you. There's no requirement that it's done in the U.S. It just has to be done before you, and they can find it. We see foreign applications cited all the time. China is an interesting one just because it's Chinese. So if the U.S. examiner is reading in English, he a lot of times doesn't know what the Chinese patent says. Right. So there might be a one-paragraph summary that's attached to it in English. But so that, I mean, in practicality, China's difficult. If you file in England, I mean, it's in English, so that's a whole other story.
Right. That makes it like virtually impossible then to be 100% certain that you really have invented something. And in Korea, there isn't some 10-year-old or 30-year-old patent.
Yeah, I think people get a pretty good idea when they do a search. They can go on just the web searches and see what's out there as far as products, and they can go on the USPTO.gov website, and there's patent searching tools, and you get a pretty good idea. I mean, it would have to be something that's almost exactly spot on that you missed using some kind of word search. I mean, they do a really good job. Some of the search engines, just the regular search engines, they do a really good job of pulling up relevant patent information, even if you're not searching for patents.
Now, if the U.S. The government site actually grants your patent.
Yes.
Now then, you find somewhere in, Uzbekistan somebody had invented it. Does that then invalidate your patent?
Depends on did they publish it? Did they keep it a secret? If there's a publication out there that's available to people in the U.S. and it was out there before you filed your application, it's possible that it could cause an issue. You can always file what's called a re-exam if you find it soon enough. Or if you kept a patent pending with the office. You could change it so that it's no longer applicable. But it could cause you some issues, and it does happen.
If you had if you could give one, very good advice to an entrepreneur or a startup with regard to protecting their intellectual property, what would that be?
Well, like I said, I would talk to an attorney. A lot of them will just talk to you for free, and actually talk to them about, hey, this is what I want to do. What do you think about it? And these are my situation. What would you do if you were me? And actually get some advice on that. I find most people, when they miss, it's when they decide, hey, I'm going to do it myself, especially with patents because they're complicated. Less so with copyrights, but just talk to somebody and see what they have to say about it. Everything's pretty unique. I mean, each invention is its own invention, so you should have a unique solution for yourself.
Right. I mean, the problem, though, is you ask 3 different attorneys, you get 3 different answers. You
will get 3 different answers. You got to decide who you like and if you think they're giving good advice.
Right. Is there, in your opinion, is it like vastly different normally, the type of things that you hear, or is it, within a small factor?
It's a small factor. I mean, there is some variance, and some of it depends on the technology. You want someone who knows something about your technology. I wouldn't go to a chemical engineer for a software problem, or vice versa. And then some of it depends on where they've worked before. If you've worked in-house, you have a different perspective than if you went to a large law firm and you worked only there your entire life. I mean, it does make a difference, but there's generally this is bad, this is good, here's some stuff in the middle, ooh, I think you should go this way.
Right, because, I mean, I've actually had calls where people have been sort of worried to talk to attorneys about their invention, thinking, oh, this is, one other person that might in principle, because the thing is, billions of dollars.
Yeah, you should sign an engagement letter, and I think most attorneys will tell you that they want one before they talk to you about it, and then your client confidentiality kicks in, and the attorney's not gonna. Signing an NDA is one thing. The attorney-client privilege, if you violate that, you're going to lose your license, both to practice patent law and to practice law, and you just put yourself out of the job. The attorneys, I mean, if they're messing around with that, then you're talking to the wrong attorney.
Right. That's exactly what I said to him. I said, you have to trust somebody at some point.
Yep.
And if you, at least in the case of an attorney, you know that that's their job.
Yeah,
to be trustworthy.
Do an initial meeting with them, talk to them for an hour, not about your invention, just see what they have to say about patents in general or copyrights or trademarks, and then if you feel comfortable, sign an engagement letter. Most people will do that without a retainer, and then go from there.
Well, this has been a mine of information for me. I have learned so much just in this short time. I really appreciate you coming and telling us about this, and I hope you'll come back and tell us more about IP related topics in the future.
Yeah.
Thanks for coming on the show.
Thanks for having me.
Pleasure. Thank you for watching Austin Business Matters. I'm your host, Atola Temadi, and I hope to see you next time.